Hi, welcome to the 2011 Legislative Review presented by the Nevada Supreme Court. I'm John McCormick and this is Ben Graham, and we're going to be going over some of the highlights of the legislation that were passed this year. Ben?
Yeah, thank you, John. Prior to talking about specific pieces of legislation, just to give a little bit of perspective, this was the 76th regular session of the Nevada Legislature, and started in February. There were over 850 registered lobbyists. John and I participated in that. John is a staff member and I as a contract advisor. Over 1,500 pieces of legislation introduced. The session proceeded along. There are a number of bills that John and I have gone through and placed in the summary, about 160 of them. Chief Justice Douglas and other of the justices participated nearly every day in the legislative process, but the main thing to remind each of us is that this is not line by line how to execute whatever the legislation was. It's really important to note that this is to place people on notice more than anything else, and then you go and read specifically the particular law and that was passed. And the text that John has put together is extremely comprehensive and makes it easy for you to access that. John?
And on that note, I'd like to say a few words about the Legislative Review publication that corresponds with this presentation. You'll find it on the Nevada Supreme Court website, nevadajudiciary.us. And that publication contains all the PowerPoint slides you're going to see today, as well as other information on various other bills and some resource information. And that document's pretty useful electronically, because all the links in it are going to be active and are going to take you to whatever site they point to, be it a specific bill, a Nevada revised statute, or some sort of resource document. There's also some resources included in that in the back of that book, including a sample of the new 5-day notice to quit or pay rent pursuant to AB 226, an index to the population threshold bill, which is AB 545, and we'll talk about today, as well as a index of all the bills by which NRS they amend or repeal. So with that in mind, I would encourage you to download that publication and follow along with us. We're going to start off today with civil legislation, and we've broken these various sections down into subsections. The first one we have is estates, trusts, and probate, and you're not going to find any of these bills in the Legislative Review book. There are a number of changes. There's including a fairly comprehensive estate bill, but these changes, none of them were particularly earth-shattering or made real substantive changes to the law. The first bill we're going to talk about is AB 420, and it's dealing with kind of general civil issues, particularly those with members of the National Guard. This bill prevents or prohibits a member of the National Guard from being served with a summons for or a notice of a civil or administrative action against them while they're on active deployment. It also takes some time and suspends any pending civil action against them while they're actively deployed. So this would be kind of in the situation where a member of the National Guard is called up and has been deployed to Iraq or Afghanistan. AB 463, the next bill we're going to talk about. This bill deals with the seizure and forfeiture of vehicles. The major issue with this is that a court has to schedule a hearing regarding a seized vehicle within 7 days, and the court must return the vehicle to the owner if in that hearing it's found that the vehicle identification number has not been destroyed or altered. So this is primarily dealing with vehicles that have had their VIN numbers changed. And this was a concern to Metro down in Las Vegas.
John, I want to talk just briefly about SB 86, and then I'm going to have you take the last item, which I think was very important. Any of the attorneys that deal in the area of eminent domain, it is a very, very comprehensive group of statutes here in Nevada. as you go through it, it's amazing some of the history where the mining industry and others have had significant authority for eminent domain, a lot different than what we would often think of. And this bill, I think SB 86, kind of narrows down a little bit of the ability of various entities to take property for whatever public type purpose that eminent domain was built to. So you know, take a look at that, and then John found one of particular importance of this.
And it was a kind of a throwback or leftover statutory provision, allowed the sugar beet pipeline industry to exercise the power of eminent domain to further the piping of sugar beets. And that authorization was removed in SB 86, and thusly their property snatching tyranny has been subverted in that manner. The next bill we're going to talk about is Senate Bill 186, which deals with letters of testamentary and administration in civil proceedings. And Ben?
This is a specialized area, and one of the things you're going to find this legislative session, there were probably at least a half a dozen uniform laws that were enacted and came into place, and this provision was one of those. And the summary, which includes protection of your identifying information such as your Social Security and whatnot, are covered in this, and continued effort to keep identity theft from taking place. But those who deal with probate, guardianships, this is a must read, and possibly rework your templates on this.
Senate Bill 194 is kind of an interesting bill from this session, as it urges the Nevada Supreme Court to amend the Nevada Rules of Civil Procedure regarding class action lawsuits, to require that lawyers disclose or make a disclosure that's similar to the one called for in the Federal Rules of Civil Procedure, Rule 23. Now, this bill was kind of an interesting one this session, and led to some unique hearings where some more senior members of the legislature had to educate some of our freshmen as to the proper kind of relations between the branches of government. The next bill, we're going to move on to limited jurisdiction civil matters, is AB 223, which deals with writs of garnishment and execution. Now, this bill exempts $2,000 in a personal bank account that is subject to certain federal laws, primarily Social Security, those type of things. So $2,000 is exempt in that personal bank account from being garnished, and in the event that a bank account is not governed by those federal laws, $400 is exempt from garnishment. So the idea here was to leave folks just at least a little bit of money in their bank accounts when they're served with a judgment and they're being garnished upon.
John, with regard to landlord-tenant and real property issues, AB 226 deals with a landlord-tenant situation and dealing with evictions. This is a real fairly contentious, because you had a number of landlord and landlord representatives that were really doing a decent job, mainly trying to get their rent, but this spells out specifically that there are certain items that a landlord must advise the tenant of, and that they really can't lock the tenant out to keep them from recovering their property. And again, I would suspect that most property managers are abiding by this, but there's always someone that needs to be reminded of gentility, and that this is a statutory provision for that.
And again, on page 96 of the Legislative Review book that I'm sure you're looking at right now, there is a copy of a sample 5-day notice to pay rent or quit that includes the new mandatory notification language that's entailed in AB 226. That form will at some point be available on the Supreme Court website as well. AB 261, this is a bill that raised the limits on small claims actions in justice court. Prior to this bill, the small claims limit was $5,000. That was raised by $2,500 to $7,500, and in kind of a unique twist, there's a new filing fee of $125 for those new small claims actions that fall within the new limit. And that filing fee was part of and fit into the schedule that was contained in AB 9, which would have redone the Justice Court civil filing fees for the first time in about 20 years. And that bill ultimately did not pass, but that's where the genesis of this fee, and it kind of looks out of sync with the rest of them now in Chapter 4.
John, as you recall, there was a strong effort to raise this to $10,000, which of course was causing considerable concern among not only the limited jurisdiction courts but district court as well. And this was a reasonable compromise, and the filing fee was allowed to be increased because the governor was essentially going to veto any filing fee increase or fee increase. But since this was going to provide something new that was really sought by the business community, this is how this legislation came to pass.
And that is a good note on the filing fee, because in general this session there was a feeling that if you were asking to increase fees, you might be out of luck as far as that bill eventually becoming law. And while we're in the same vein and talking about landlord-tenant as we have previously, AB 398 deals primarily with commercial landlord and tenant issues, and this changes some provisions in the statute to prevent landlords from interrupting utility services, removing furniture, etc. When there's a dispute or the tenant fails to pay rent. This also reiterates that justice courts have exclusive jurisdiction in this area of commercial landlord-tenant matters. And this also makes some changes regarding claims that landlords can make against tenants, and does a few things with, excuse me, with abandoned property. So that bill, again, deals a lot with commercial landlord and tenant, and is limited jurisdiction in nature.
The session was dominated by several topics. The most important one was the lack of money revenue for the state to hopefully conduct themselves with what would need to be done. But the other was, of course, the fiscal crisis dealing with homeowners and foreclosures and the various lien holders that you would find. So if you look to see the bills that were introduced, there were dozens of those, but ultimately a handful were all actually passed for various reasons. There's a study being conducted between now and the next session dealing with the foreclosure process, so there probably will be some legislation in 2013, but AB 273 did come out of that, and that was to guard against additional liens being placed on by secondary lien holders, jeopardizing the free sale of a clear title to some of these properties.
And you'll also note here that AB 273 ended up making changes to AB 284 of the 2011 session. So that'll tell you that this was passed after 284, and they had some second thoughts after passing that one. And speaking of 284,
again, it's amazing the number of changes that were tried to alleviate some concerns, many of which were being answered as the session was going on in the mediation foreclosure process. And 284 again dealt with a fairly comprehensive matter dealing with the assignment, the duties of the mortgage trustee, notice of default, civil penalties, and fraud matters dealing with foreclosures was increased from a gross misdemeanor to a C felony.
AB 388 was a unique piece of legislation this session. It started out completely kind of altering the way foreclosures were handled, or would be handled in the state of Nevada, and it mirrored some legislation that was at the time under consideration in California and ultimately didn't pass there. But AB 388 became a compromise bill, and I'll let Ben talk a little bit about it.
Well, 388 and one coming up, 307, as indicated, several others, there was a massive attempt to completely legislate various processes with regard to mediation and the foreclosure process. And this was an effort to make sure that a person whose home is being foreclosed on has a viable phone number to get a hold of someone, and to make sure that they are dealing with a person that has authority to potentially modify a mortgage. Again, there were probably half a dozen legislators and many others working on altering the foreclosure process. It was urged that we go slow on this to allow what happened in '09 and to gel a little bit, and to allow the courts and the process to work out the problems that were confronting these people. That's the same on 307, which again was another mortgage foreclosure process. Again, we were told by the banking industry that most of these things now are being done. And again, it was an effort to provide contact information not only to folks that are losing their home, but to attorneys and other lenders that were trying to assist them. And then moving on again to SB 414 dealt with short sales. And the testimony that we heard is that there were folks that were either purchasing or were in the process of a short sale, and they thought they had it put together, and the left hand of the lending institution apparently didn't know that, and the short sale would fail because the home would be foreclosed upon. And this is SB 414. It was an effort to speed that process up, so that that you'd be able to have this short sale. And this also deals with a deficiency judgment, which is a fairly new animal here in Nevada. So take a look at that in SB 414.
The next section of legislation we're going to talk about in the civil arena are a number of the uniform acts that were passed this session. The first one, AB 87, deals with interstate dispositions and discovery, and this sets up rules for dealing with out-of-state litigants and subpoenas, etc. And that again is a uniform act from the Uniform Commission. And there were several other uniform acts that were passed. There was one that amended the commercial code, so you're going to want to take a look at that. And there were a few others that made some changes to some fairly specific areas of law, including property and estates, when the property had a sentimental value but maybe not necessarily a monetary value. With that, we're done with our review of civil legislation here, and we're going to move on to looking at the bills this session that dealt with concealed weapons and self-defense.
John, we've worked the legislature for several sessions now, and firearms and pit bulls are an area that are always of great interest and concern. And this was another session where we really didn't anything on pit bulls that I remember, except just cruelty. We had
there's something to deal with cruelty, and we'll get to that a little bit later.
Right. Concealed weapons. Actually, I think the legislation that came out this time.
And again, I'd remind you that there's more bills than we've covered reflected in the legislative review book that you're looking at. And also, if there's other bills, like maybe dealing with common interest communities that you're interested in, that we didn't cover in depth, always remember to check out the legislature's website. It's a wealth of information. They do a great job. And also, in your legislative review book, you'll find a link to that website and a link to a number of other interesting or useful websites, and my contact information if you have questions, starting on page 93.
And please, 2013 sounds like a long way away. But if you have legislative issues, and I hope that you don't, because it's better if we don't, but if you do, now is the time to bring them up and to start working it out, and let John and I know, and we'll help in any way we can to formulate a process that you can get your needs addressed. Okay?
And with that, we thank you for taking the time to watch.
Thank you.